Donald at 4:47 yesterday afternoon, Trump's lawyers stopped talking. Not the deliberate silence of lawyers talking before making a statement. The people who are paralyzed by silence just saw their whole plan fall apart in real time. Because 18 hours earlier, when most of the U.S. was asleep, the U.S. Supreme Court made a decision that was so bad, so strong, that it wiped out every legal Trump has been creating protection for 3 years. Every claim of immunity, the argument for executive privilege, his lawyers used a delay strategy across 4 criminal cases, and a lot of civil ones. Lawsuits are over. In 247 years of the Supreme Court's history of the Constitution, the court has never taken away a former president of legal defenses this in a complete way. Not Clinton, not Nixon, not a single person. And this is what you should be scared about. You should know this about this moment. The 3 judges that Trump himself chose to that court, the judges who were expected to be his firewall and his insurance policy, they voted for his final protection against him without a doubt. If you want to realize what just broke, not in sound bits from cable news, but in the legal mechanics that will decide if a former president visits to, if you want to go to prison, subscribe to this channel now. Now, because of what I'm going to show you isn't being explained anyplace else. The time just started ticking, and Trump has 2 weeks to answer something. His lawyers believe it is against the law to answer. The decision you have been reading in the news, the one that every media is covering. This is the public version. 63 pages of legal arguments that the Supreme Court gave the press and put on their website for anyone to see, download. But there's more, something that very few people are discussing about, since very few people know about it. There includes a 47-page sealed appendix for lawyers' eyes only involved, and the judges who need to see it. And a source says that direct understanding of its contents, one paragraph in that appendix, only one, has proof that is so bad that it could lead to immediate criminal connections to 3 different grand juries. Let me show you the second one now, paper that you haven't seen. In the beginning drafts of this Supreme Court decision, there was a disagreement. Justice Clarence Thomas had penned a scathing 32-page argument in favor of absolute presidential immunity. Justice Samuel Alito signed up. Justice Brett Kavanaugh was leaning toward being with them. We are aware of this when people talk about draft opinions inwardly before they are set in stone. That is what the Supreme Court does. Method. But then something occurred. On the 8th of January, the judges got a secret briefing from the Department of Justice. The subject was national, what the Trump cases mean for security. 2 hours in private. And when after the briefing, Thomas took his disagreement. Alito never sent in his agreement. Kavanaugh turned totally. The last decision was all 9 votes were in favor. Every single justice, which includes the 3 Trump appointed, ruled against him. What was in that meeting? We don't know. It is still secret. But whatever proof from the Department of Justice showed those judges was very convincing enough to go against every ideological, every political loyalty, every impulse, every worry about institutions' precedent. It persuaded the majority, conservative members of the Supreme Court, that it was better to protect Trump than to let him go, more risky than the other option. And here's the third document that changes all of it. On page 34 of the A ruling is a deadline for filing. You have 14 days from yesterday to turn in an official reaction. But lawyers I know have talked to people who have been working on constitutional law for decades. Everyone has said the same thing. He cannot answer, since the proof he would have to give in to defend himself would also make him look guilty in 3 more cases that are still open. To get at why Trump's lawyers are in a full-on panic, you need to comprehend this right now. The 5 terrible mistakes that caused up until this point. 5 choices that looked like a good idea at the time, but were actually making a trap that just snapped shut. The first mistake is playing the immunity card too much. When the D.C. Circuit Court of Appeals turned down Trump's assertion of total immunity back in February 2024, his legal team had an option: accept the loss, move forward, and stay focused on other defenses. They instead filed an emergency request with the Supreme Court. They thought at the very least, the conservative majority would give them a listen, give them time, maybe even make a decision in their favor. What they got was quiet. The Supreme Court didn't say anything for 11 months. The court didn't say anything. And Trump's lawyers thought that quiet meant they were thinking as the justices carefully considered difficult questions about the Constitution. They were wrong. That quiet was what everyone agreed on making. The justices weren't arguing if they should protect Trump. They were making an opinion so strong that no future president could never say what Trump was saying. The second mistake, the difficulty with the testimony. Do you remember when Mark Meadows was given limited immunity to provide evidence before the 6th of January group? That was important, but it was not the atomic bomb. There is second witness, a lawyer for Trump team doesn't know, has worked with lawyers. This is what was filed in court. The person's name is merely a code name, one executive assistant. This person was there for phone calls. Trump currently claims that never happened. Present for Trump says the discussions were about the election, not changing the findings, but security. And this witness just turned in 9 or 17 pages of notes taken at the same time to federal prosecutors, written by hand, with a date, every talk, every time, every moment of panic, and every command as the violence on January 6th got worse. My mistake number 3, not paying attention to the connection to Georgia. While everyone centered on the federal cases against Jack Smith's trial in Washington, D.C., Fani, the district attorney for Fulton County Willis, was working on something else. A racketeering case in full under the identical Georgia state law proof, the same witnesses, the exact same time frame, and here is the trap that Trump's staff missed. The court's decision doesn't only apply to federal cases. It directly says in Section 4, Paragraph 3, that the immunity analysis is the same for state court processes, which means as soon as that verdict came out, every Trump was going to use an immunity defense use in Georgia disappeared right away. The trial date Fani Willis has been pushing for April 15th. That is 11 weeks, starting today. And unlike cases in the federal system, state convictions cannot be forgiven by a president ever. The fourth mistake, the cash. Trump's lawyers have been so concentrated on being caught that they seem to have forgotten about the civil cases. The $8.3 million judgment in the $450 Eugene Carroll defamation case, million judgment in the New York attorney, the fraud case against the general. Both of those decisions have been put on hold until appeals based mostly on grounds of immunity and executive privilege. The Supreme Court's decision simply got rid of those points of view. The seizure of assets can begin in 30 days. So what does Trump do now? His lawyers are in a hurry through 3 different ways to get out. Let me show you each one and tell you why every option leads to calamity. Getaway route number 1, file an emergency stay. Ask an individual Supreme Court fairness. This is a normal legal move when you need to stop a ruling until you get ready to file a comprehensive appeal. This has already been tried by lawyers. They filed with Justice Samuel Alito, the court's most conservative member, justice most likely to be understanding. Alito turned down the request in 4 hours. 4 hours. For example, an emergency stay applications normally take a few days, sometimes weeks, for a judge to think about. Alito read the filing and commented no almost right away. And this is what that tells us. He has seen the closed proof, the secret appendix I said before. No matter what is in those, even Alito was convinced by 47 pages that Trump's assertions of immunity are not only weak, but also silly, way out. Second, call on the political question doctrine. This is a legal theory that says courts shouldn't decide things that are inherently political, that some questions are part of not the elected branches of government, the courts. Bush and Gore had a version of this argument in 2000. Trump's team is thinking about making a claim that going after a former president is a political question that courts cannot decide. But here's the issue. The Supreme Court already knew this would happen, argued and destroyed it before it could happen. The majority on page 78 of the ruling, the opinion, clearly talks about the political question doctrine and elucidates in excruciating detail why it doesn't apply to criminal cases of anyone, even former presidents. The language is clear. It's a door being welded shut while you are still on the wrong side. Number of escape routes. 3, the nuclear choice. And this is where it really gets dangerous for democracy in the United States. People close to Trump's lawyers say they are talking about questioning the Supreme Court's authority itself, saying court's authority, making the case that the court went beyond its Article 3. This is a violation of constitutional powers. Decision. This isn't a theory that isn't well known. This is crazy in the eyes of the law. Not credentialed lawyer wants their name on a filing that questions the authority of the Supreme Court basic power. But here it is, the scary part. 3 lawyers have already left Trump's team in the past week instead of filing this motion. One of them used to be a member of the Federalist Society board member, a very strong conservative who has stood up for Republican causes for 30 years. Now, let me show you what the Supreme Court said in this decision that has lawyers calling it the most important opinion on the power of the president in 50 years. I'm going to show you 5 specific passages that make everything different. Passage first, the rejection of immunity. On the court writes on page 23, and I am directly quoting, no person in the United States, no matter what position they hold or previously held, is above the criminal law when private acts happen are alleged. That might sound like normal legal language, but look at what's next. The court adds in parentheses, this includes sitting and past presidents. No, they didn't have to add that phrase. The sentence is correct without it, but they added it on purpose because they are not just deciding what to do about Trump's case. They are setting a standard for the next president. No future. The chief executive can never say what Trump tried to say. The Supreme Court, I just took that tool off of the forever in the presidential toolkit. Passage number 2, the proof normal. In most cases of crime and prosecutions, the government has to show without a reasonable doubt that the defendant meant to break the law. But hidden in footnote 19 on page 41, the court does something amazing. They take on what is known as the reckless standard for cases that involve official acts and former presidents. In simple terms, this means that prosecutors do not have to show that Trump knew he was violating the law. They just need to show that he ignored clear warnings that what he did was against the law. And we have 17 documented cases of the White House. Pat Cipollone, the lawyer, clearly told Trump's plans after the election broke the law at the federal level. 17 warnings in writing with people who saw it. In a part, the third thing is executive privilege, not the case. For decades, talks between a president and his closest advisors have been shielded by privilege for executives. Presidents need, the theory says, that honest advice is what you need, so those people need to keep their conversations private, even after they leave work. The Supreme Court just made a huge that rule doesn't apply here. On page 56, they write that executive privilege doesn't not apply when messages were sent for the purpose of committing a crime. The legal term for this is the crime fraud exception, and it has been around for lawyer-client for years of privilege. The court just added it to the president's privilege. What does this mean in real life? It means that only Pat Sip can testify about everything. Mark Meadows can give evidence about everything. Vice President Mike Pence can testify about every single talks he had with Trump about overturning the election, which includes talks that took place in the Oval Office, in the White House home on the Air Force One, everything. There is nothing not safe anymore. Number 4, the trap of making documents. Here is the footnote that no one saw. Note 47 on page 112. It has to do with documents requirements for production. The court says that when a past president says certain papers are protected by he must show executive privilege, those papers to the court for ink review of the camera. That means Trump has to give the papers to a judge who will look at them in private. But here it is the problem. If those papers show the privilege does criminal activity not apply and they become proof. Now, let me show you what happens when you put all of these trial dates on a calendar, because when you see them laid out visually, something scary happens. This isn't just a number of cases. This is a crash, course made to make compounding happen, a legal disaster. February 7th. That is 14 days after the Supreme Court the ruling was dropped. Making documents, due date. Trump needs to choose whether to give the privileged documents to the court, is asking for or going against a direct order from the Supreme Court. If he makes them, they become proof in many cases. If he doesn't agree, that's a crime, disrespect, and possibly obstruction of fairness. February 15th, 3 weeks from now, Fulton County District Attorney, now Fani Willis, has set a date for a hearing to set the date for the Georgia RICO trial, based on the Supreme Court's decision to get rid of. Legal experts think that immunity defenses will her to ask for a trial right away. The April is the date she has been pushing for. 15th, that is in 12 weeks. March 4th, 6 weeks away. This was Judge Tanya. The first date for Chutkan's trial was case of federal election interference in Washington, D.C. She delayed it pending the appeals for immunity. Those appeals just got obliterated. People say she will reset the trial for late April or early May at a hearing scheduled for March 4th, March 15th, 7 weeks. The New York civil fraud judgment becomes final and enforceable. Attorney General Letitia James can begin asset seizure proceedings. We are talking about Trump Tower commercial spaces, 40 Wall Street, the Seven Springs Estate bank accounts. The $454 million judgment starts getting collected by force April 1st, 10 weeks. The classified documents trial in Florida. Judge Alan Cannon has been putting off this case for months by using arguments for immunity as a reason. The Supreme Court's decision just hurt the only reason she gave for putting it off. The 11th Circuit Court of Appeals can now tell her to go right away. 12 weeks from April 15th, the trial of Georgia RICO starts. 19 people are charged with 41 crimes, charges of conspiracy to commit racketeering. This is the big one. Charges from the state. No, a federal pardon is possible. And here is what makes this a downward spiral. Every trial gives us evidence that we can use in the next trial. Testimony from Georgia shows up in D.C. transcripts. D.C. files show up in court in New York. Federal convictions affect the jury pools in each state. Every case affects every other case. More powerful, there is no way to get out. You can't settle criminal cases. You can't get rid of them when immunity is gone. You can't forgive state convictions. Now, let me do something that very few people do. Someone else can cover this story. Please let me make the best case possible for Trump's defense. Because if I can't deal with the most convincing version of their arguments, then I'm not really looking at this situation. I'm just cheering the first argument. This is about politics, the prosecution. The timing does seem very useful. All of these situations speeding up at the same time in a year of the election when Trump is the leading Republican. No former in all of American history, no president has ever been charged with a crime. The whole thing, it feels new because it is never before seen. And how it looks, it's hard to ignore political motivation. This is where that argument falls apart. They would have charged Richard Nixon. Gerald Ford specifically pardoned him so that stay out of jail. Bill Clinton was charged with lying under oath. But the standard for lying about a personal affair is not the same as getting a mob to stop the passing of power. The first time ever part is not the prosecution, it is the behavior. We have a recording of Trump asking Georgia's Secretary of State to look for 11 to 80 votes. We have proof in the form of documents of a scheme with fake electors in 7 states. We have 2 hours of violence at the Capitol that Trump saw on TV while refusing to call it off. The why no president has been charged before is that no president has done what Trump did. The second argument is that the Supreme Court is not fair to Trump. He just got 3 of his own justices to vote against him. Conservative news is already saying the deep state got into even the Supreme Court. Then please explain this. Why did Samuel Alito, the most conservative judge on the court, vote against Trump? Why did the court rule in Trump's favor on presidential access to records back in 2020? Why does the majority opinion cites the Federalist Papers and decisions by Antonin Scalia over and over? There is no bias in the court. The law is clear and the evidence is strong. Clear. This is argument number 3. Using the justice system as a weapon. Democrats are using the courts to get rid of a political enemy before the election. Let me try that idea. If this is weaponization, why did Trump do this? Judges he chose turned down his immunity. What are the claims? Why did the Republican state people in charge, like Brad Raffensperger, and did Gabriel Sterling testify against him? Why did Bill, his own Attorney General Barr, said there was no fraud in the election? I want to show you three possible futures for America, depending on how this goes, because of what will happen in the next 90 days doesn't just decide what happens to Trump. It decides what kind of country we are. Number one, in the future, accountability holds. Trump is being tried in a number of jurisdictions. There is proof in court is open. Juries listen to people testify, witnesses who are sworn in. If the proof proves guilt beyond a reasonable doubt, he is found guilty. If it doesn't, he is not guilty. The system works in either case as planned. This sets a standard for clear. The law applies to everyone, not billionaires, not presidents, not political leaders from any party. The price is short-term political chaos and social division. The benefit lasts a long time. Trust in institutions. Democracy shows that it can hold powerful people accountable, responsible. Number two, for the future, responsibility fails. Courts get scared. Witnesses are threatened and refuse to speak. Judges step down, putting themselves under stress. Juries get doxxed. Cases get thrown out on details. Trump leaves without never getting a verdict. The precedent, this set is a disaster. It says every president you can think of in the future commit crimes while in office and be held accountable. No consequences as long as you keep political power and keep your base put into action. The law becomes for the powerful. It's up to them. And the next authoritarian who comes along, someone more disciplined and smarter than Trump, finds out exactly how to use that weakness. The third future number, break. Different courts in different jurisdictions arrive at disparate endings. Judges in red states throw out cases as political persecution. Blue state judges find people guilty. Courts in the United States split along political lines. We end up in a situation where Trump is found guilty and then let go at the same time. It all depends on which court you ask. That this causes a lot of chaos. What are courts real? Who makes the decisions? What do we follow? Law is no longer a neutral decider and becomes just another weapon for one side. And when the law doesn't settle arguments, force fills the vacuum. We have seen this pattern before other nations. It doesn't stop in a peaceful way. This is what happens in the next 72 hours. Trump's legal team will be in court on Monday. Team needs to send in their answer to the Supreme Court's decision or a written admission that they can't. Fani Willis on Tuesday has a press conference in Atlanta. Look for the announcement of the trial date on Wednesday. Judge Chutkan has set a hearing in Washington. She could start over the trial in federal court for April. And here it is, what I'm looking for. Number of signals. One, a former member of the White House counsel speaking in public, Eric Hirschman, just pat sip. These lawyers never talk about ongoing cases unless they are very serious cases, unless things are very bad. If they begin to do interviews on TV, it means they have been let go from limits on attorney-client privilege and the dam is about to break. Signal second, Mike Pence's testimony plan. If he is asked to testify within 30 days, the prosecutors are moving as fast as possible. Signal three, Republican senators are being quiet. When Lindsey Graham even stops defending Trump on TV, when the most loyal allies suddenly don't have anything to say, which is when you know the end is close. This is the most important legal story of our generation happening right now. Sign up now and turn on alerts because the next 90 days will go faster than cable news can process. Send this video to everyone. Who still thinks this is okay politics? No, it isn't. Leave a comment below. Do you think Trump will follow the Supreme Court's decision or not? I will be back in 2 days with an update on what's going on behind the scenes in Georgia. Something is happening that changes it all. The walls aren't not closing in anymore. They are now closed. Now, the only question is if there is a method